I'm very happy to have one of my co-authors, Professor Richard Gruner at the University of Southern California Law School and at John Marshall Law School in Chicago. Richard will talk a little bit about his career and talk a little bit about things we're talking about during week one, which is about the commercialization of intellectual property. So welcome, Professor Gruner.
Great to be here and to be part of this important course.
Yeah, thank you. And so what exactly is intellectual property commercialization for people who are just having their first week of intellectual property? What does that term or concept mean?
The net concept is it's the payoff. It is the means by which parties that have intellectual property rights gain some reward, usually through commercial processes, hence the name commercialization. But the means by which that can happen can vary widely in different fields and different business contexts. For example, one way that a company that has its own patents might realize intellectual property mediated returns is simply by charging higher prices than competition would normally create for the same product. So if you develop a patented drug, the patented drug will probably sell at a higher price than the unpatented version later on. And so in that period of patent control, some of the reward comes from elevated prices. Another approach would be if you had a valuable IP, you might engage in IP licensing, which is to transfer to a different party the exclusive right to make something with the IP incorporated in it. For example, Disney, although a great generator of IP and also a great realizer of profits through its own movie distributions, also is a massive IP licensor. And so when one sees a Disney character appearing in other businesses' contexts, like the Disney characters that might appear in a Happy Meal at McDonald's, that's a product of IP licensing, and Disney has received a fee accordingly. So as it turns out, Disney, although it makes enormous amounts from its movies and its theme parks, makes more from IP licensing than anything else. So IP licensing is a massively important piece of this field as well. And then finally, for some companies, another way to commercialize, although you might not think of this as part of that process, is in sale of a company that controls valuable IP. Many startup companies in Silicon Valley or elsewhere have exit strategies that are basically a desire to sell the company to a usually larger company that will scale up production. But what's being sold in those kind of contexts is usually the intellectual property that controls the key product. And then the bigger company can now own that IP and utilize it in a broad scale manner. And they're going to pay the startup company for that opportunity that they buy into by buying the company. So the actual sale of the company is essentially an IP influenced chance to commercialize the IP involved.
Yeah, so we have licensing, we have a sale of a business or sale of assets, and also as collateral, right? If you're thinking about the lending process as a form of finance.
Indeed, and many startups, that is a key source of financing in the early periods of the company when they don't really have products going out the door yet. They have perhaps produced valuable IP and gotten a patent on it, and a bank will be more willing to give a loan, or other lending sources will be more willing to give a loan if they can be reassured that they have some collateral to ensure repayment of the loan, and often those IP assets are the collateral.
Yeah. Are there any industries that aren't affected by intellectual property commercialization? Are there some more than others, or is this something that we can expect to come up in many areas of practice that our students might enter into?
You know, as you ask that question, I'm trying to imagine a field that does not have significant IP commercialization. IP goes with creative effort. And so any field, any business in which creative effort is at the core of creating items of business value or carrying out a business in a valuable way will have important IP issues and therefore important IP commercialization opportunities and features. One of the things we've learned about many businesses is that if parties, and this will include your students in the future, if parties start to think creatively about how businesses can extend or further utilize their intellectual property, new business thinking and new business opportunities to often result. For example, a business that is already profitable and producing a product may be able to license the opportunity to produce more units of that product to somebody else, either to service other parts of the country, or, as is increasingly common, to service different countries in the world. So licensing the opportunity to produce a product in China or in other countries is an important feature now of international IP commercialization, usually achieved through licensing.
And it's also important to point out that it can be for nonprofit as well as for-profit entities, right?
Indeed, and in the non-profit setting, there are both what I would say are still commercialization processes as well as reputation maintaining processes. And a fascinating example that I've been researching lately involves the Girl Scouts, which is a nonprofit organization, but is very sophisticated, particularly about their brands. The Girl Scout logo and brand, they both achieve what is essentially a commercialization process through things like their cookie sales, but they also control their trademarks carefully to control what organizations, particularly the local Girl Scouting organizations, can administer Girl Scout programs. And so they are very thoughtful, very sophisticated about both the reputational use of IP as well as a fund generating process that they engage in every year.
And it's really hard to find an entity, profit or nonprofit nowadays, that doesn't use some sort of an app for a smartphone, right? And that definitely brings in IP and commercialization issues.
In several levels. One is that often those apps are designed to propagate their brand name, and the brand is typically a trademark protected feature of the company, but also the app itself is a bit of software that either they've generated or they've contracted to be generated, and they will typically want to control that app, and that in turn involves software copyright issues usually. So there's IP in layers in many situations like that.
Yeah, it might be worth mentioning that, when we're recording this for the class, we're doing this April 2020 during the pandemic, and I had a couple of students at Syracuse, enterprising students I was talking with yesterday, that they're actually out your way, Richard, in Los Angeles. And they have this idea of designing and making face masks, not for hospitals, but for everyday use. And even though they want to distribute masks for free, they have to worry about the IP involved with the design of the mask and the manufacturing and those types of issues.
Well, in fact, those, even in settings like that, where one hopes to freely distribute a product, one has to be concerned about what inputs are being incorporated. The classic setting where that's come up and has been a bit of a sticky point is the open source development of software. The open source community very laudably often wants to add to the features of a product and then distribute that enhanced version freely. The problem is that their work, their increment, they do control. But if they've incorporated someone else's copyrighted content in the base product that they work from, they have an issue about further distribution. So even with the best of intentions, people need to at least be thoughtful about IP limitations.
Yes, yeah. Well, we'll talk about those limitations and also the type of IP you need to protect throughout the semester. And so we've been talking about different IP terminology, patents and copyrights and brands. Would you like to comment a little bit about how IP commercialization might differ across these different types of intellectual property? And, it's a little bit unfair question because that's what we're going to talk about over the next 12 weeks, but you have the power of the precedent here.
Well, and frankly, I've been thinking in those broad terms right now because I'm teaching an IP licensing course at USC, and the breadth of not only IP types in play, but licensing settings is really remarkable. The more I explore this area to teach about it, the more good examples, interesting examples, examples beyond my own experience that I have encountered and which people are making great successes in pursuing. So IP and IP commercialization are again, and you see creativity. I think that's the linchpin, is that if people are being creative, either for their own sake or because they see that by being creative, they can serve the need of a consumer set, then there is going to be new intellectual work being created that may, if the parties choose, be controlled by intellectual property. Now, you as an originator of new creative works can choose to release that to the world, so long as you haven't incorporated someone else's work, along the lines of the open source example that I gave you before. But oftentimes the artist or the software designer or the engineer who creates a patented invention will have great control. Now, having said that, that control may already have been given up. So for example, if you work for a big company, or for that matter, do your work in a university environment, it's typical that a skilled engineer or scientist will have signed a patent assignment agreement. And that agreement indicates that if I create a patent invention, I will assign it to my employer or to the university if that's the setting. And so when the invention occurs, it's not quite the case that the individual controls the patent. He or she nominally will control it very briefly, but has an obligation to then give it over. And so the ultimate use or application of that patent will be in somebody else's hands. But in terms of how the different types of IP lead to different types of commercialization, you know, the differences derive directly from the nature of the different IP rights. So trademark rights typically are about identifying the source of products, the settings where those can be commercialized derive from notions of, well, who has a valuable brand and how might that be propagated through either new types of business sales, new types of products, or in new geographic settings. So you tend to see brand extension in settings where there's already something of significant high reputation or high popularity. Having said that, though, the nature of the high popularity, there's so many people extending what I would think of as personal brands, you know, the Kardashians, et cetera. They're able to tremendously commercialize popularity of various sorts. Patented technology, the extensions are in both industrial and consumer environments. In a consumer environment, a patented feature may so enhance a given type of product that all of a sudden that brand's product or that company's product wins over the marketplace in a consumer setting. On the other hand, it may be an industrial patent. It may be a patent on a machine that produces car parts in a better way. And by lowering the costs of producing a part or producing it with greater quality, the manufacturer who has access to that patented industrial device can cut the price of their cars or produce more cars or do something better within their business. And so that's another common means for commercializing patented inventions. Copyright is a very broad field as well. We think of it in its basic form as about books, but it's not about books anymore. It's about movies and software and many content related features that are now being propagated in remarkably diverse ways. In fact, the streaming that we're doing right now wouldn't have existed just a few years ago. And so many of the movie industry and entertainment industry practices now revolve around streaming oriented commercialization. If you wanted, the best example I know in the last few months is track Disney Plus. Disney Plus is a spectacular success, even before the new conditions that probably are increasing their streaming. And it's all about reutilizing older intellectual property. They've figured out a way to newly commercialize the old Disney classics and a lot of new Disney material, and of course the extended set of Disney material, which now includes Marvel and Lucasfilms and all the others. So they figured out, though, a new context, this whole streaming platform, in which to gain some return for the value of those intellectual products. And then finally, trade secret. I never want to leave behind trade secret law, because in many ways it's the broadest and sometimes the most important of all the IP dimensions. Broadest in the sense that many confidential features that are of value to companies can be trade secrets, down to the how did they construct their customer lists for targeting advertising or calls on customers, choices that they have made that the other competitors in the field don't know of and that give some value to the company that does know of it. Those features can be protectable trade secrets. Where are trade secrets commercialized? Well, often it's just in the internal operation of the holder of the trade secret. They just do a better job because they have the trade secret knowledge. But it can also be a source of licensing or enhancing other licensing. It is typical when a patented product is licensed to a second company that various trade secrets will be handed over to that second company to help them make full use of the patented technology. And so often trade secret commercialization goes hand in hand with patent commercialization or other technology commercialization.
Yeah, we're going to spend the first, we start off with trade secrets, and as we'll see, it'll kind of permeate a lot of what we talk about. I mean, the very first case we'll do, the learning curve case in trade secrets, is about, it's a commercialization case. It's a very interesting case, and we'll see it again in some of the later cases in patents when you're thinking about commercializing inventions. Trade secrets can be very important at the early stage when you don't want a competitor or the rest of the world to know what you're developing. Trade secrets can be essential there so that you have that edge that arises. So that's
and
very
they're
important.
also easy to gain. I mean, all you do is build up the confidential knowledge and keep it confidential.
Yeah.
It's not like a patent where there's a fairly elaborate application. The trade secret is there so long as you're a bit careful about keeping it confidential.
Yeah, absolutely. We'll talk about those issues, especially how it might be easy to lose, too, with reverse engineering and some of the enforcement issues. So, so that's very helpful. Thank you, Professor Gruner. And one of the things that's also worth segueing into is you've had a very distinguished career. You started out at Caltech as an engineer, and then I think you worked probably before IBM. You had some positions, but you're at IBM for a number of years. So what type of advice would you give to our students, both students who have a tech background and then students who may not have had a tech background but are very interested in intellectual property?
Well, first of all, there are many ways to get involved with an intellectual property practice, whether one has a tech background or not. And there's so many sides of the intellectual property field and then intellectual property commercialization that are not high tech. So let me give it two answers here. One is for any party with any type of background who's interested in intellectual property. I think it's a tremendously important field to consider as a new lawyer or as a lawyer in training, because so many business settings turn on intellectual property and its full usage or its improper usage. In other words, as I think we'll talk about more, at least a large part of this field is not making large mistakes that hold up a business or that cause great extra costs that might have been avoided. So intellectual property, both as an asset building tool and as a problem avoidance tool, is at the heart of just about every business enterprise today. And so if one knows about IP and knows about the opportunities and risks that it entails, you can be a tremendously valuable person in a variety of legal settings. That's the general answer without a high-tech background. For persons that have a high-tech background, and this I'll comment on my own experience and changes that I might have made if I could redo it. I came out of Caltech. I did have an applied physics background, mostly involving lasers, but I did not start out as a patent attorney. I started out as a general member of the legal department at IBM, where I had a spectacular set of experiences. They throw at least in that area, they would put their lawyers into very sophisticated settings very early in their careers. So I learned a lot at IBM, and I worked with wonderful people. But I was working in a general legal capacity, and we worked with a division of IBM that sold large mainframe computers, which were each transaction many millions of dollars. So a lot of careful work on a few transactions. That environment obviously is very different today, and I even recently looked up, well, what is IBM like today? They still are an IP-intensive company. They engage in a lot more IP licensing. They provide a lot more consulting services. They still sell a few very high-end products. They are responsible for many of the cloud computing computers that are in various data centers run by Google and others. But it's an indication, just focusing on the IBM story alone, of how the nature of the practice you might have in an IP-related area will almost certainly change dramatically. However, if you're interested in IP, you will be in a position to change with it. In other words, the best part of being an IP lawyer, an IP-related lawyer, is you're working with the people who are creating the next round of activity and products, et cetera. And so you're learning with them, and hopefully you're providing good advice about the new features of IP law and the new features of business content and the legal issues that come out of those. You know, right now, if I were coming out of law school, I'd want to learn about things like cloud computing. I'd want to learn a lot about encryption. I'd want to learn a lot about computer-enhanced discovery processes, maybe a lot about computer analytics. I know, Shubi, you've done some interesting recent work about how analytics are transforming legal practice.
Right.
I think that's and by analytics, let me unpack that notion. In many business fields now, there's a lot more attention to data on day-to-day business activities and then analyzing it and also testing alternative ways of doing things. Because we have such strong computer analysis abilities, various businesses can review those practices almost real time, particularly internet or other computer-based businesses. They just have tremendous amounts of data, and now they realize we can make a lot better decisions if we analyze the developments going on in a very quick and almost real-time basis. That whole notion of business analytics hasn't quite propagated to the legal world yet. It's starting to, and I think it's going to have many implications in the next decade or so for lawyers, for how they administer legal services, how clients expect their legal services to be given and priced and focused, and also just the nature of what you might be giving legal advice about. If we can detect in a sales environment, let's say, that a certain feature of a car is causing customer disputes, well, all of a sudden that should trigger investigations, maybe some legal advice early in the development of the problem in a way that it hasn't in the past. But analytics and a sensitivity of lawyers to analytics can enable those kinds of better problem detection and problem response.
Yeah, and I know we're trying to emphasize that, certainly in my classes, we're trying to integrate a lot of those issues to try to understand technology in the broadest sense, how it integrates into different areas of practice, as well as, you know, it's just part of the environment very broadly, the business environment, the social environment that, you know, the next generation of lawyers are going to enter into their practice. So.
Well, and there are so many tools now. Again, in a legal environment, maybe some of the students have encountered these tools, but I am just now working with a program called Tableau, which is one of the data plotting and graphic programs. And through Tableau, you can manipulate the entire Google BigQuery cloud computing system. And so from your desktop, you can manipulate massive amounts of data and data processing capability, and then generate interpretive statistics from that. So that's the sense of which computer power is going to be available to us as lawyers, as individuals in the future. very easily and without even a lot of computer programming or computer management knowledge or personal control. It's going to be via the cloud.
And it's going to come up in a lot of areas of practice, even if the students in this class don't enter into an intellectual property practice. They end up into general practice, or they enter up into a corporate practice, or even if they enter into certain aspects of public interest law, because a lot of these issues we're talking about raise important questions about privacy, due process, how far can the state go, and these are really interesting issues, important issues for the next generation of law students to be involved with. Maybe as we wrap up a little bit, what kind of guidance or pointers would you give to students just entering into the field of intellectual property and the study of intellectual property in terms of what they should look for? This is typically a second-year course or a third-year course, but most students would have gone through how to read a case, how to read statutes, and we're going to work on that even more. But there are also additional skills that they should look out for. What would you guide students in terms of what they should get out of the class? And really, I guess this is, what should they expect from me, and what should they be asking of me as we go through the material?
And so several layers of answer to that. First of all, I would counsel students over many years in legal teaching is think about enhancing the skill set that you've already brought to law school and will bring to your careers ahead. If you have a background in a particular field, that may make you a better lawyer in that field, and you would want to focus particularly on the IP issues that will build upon the skill set you already have. Having said that, though, I think there's great importance in having at least a taste of all of the IP types. Even if you think now that you're going to be a specialist, you may have a technical background and expect to be oriented towards patent law, but you should know a substantial amount about copyright and the other IP areas, if only to be able to triage problems, to recognize problems, and then get other specialists involved to know that a patent setting also seems to involve some software, which will raise software copyright issues, that you've already partially triaged the situation. And so knowing a bit about all the range of IP areas, I think, is important. Beyond that, my next level of advice, and by virtue of the fact that I'm speaking to your students, they've already been lucky enough to get this, is take a class that emphasizes the transactional nature of IP interactions, because that's actually the way most IP lawyers practice. There is another branch, which is IP litigation, and those are important practice-oriented opportunities too. But most IP is of importance in working with transactions and working with clients in their future activities in what is essentially a planning process. You can plan a given transaction, or you can help a client plan business expansion or business change or response to threats. Oftentimes, a client comes to you saying, I've gotten this cease and desist letter. What do I have to do about it, if anything? And so planning the next step is the essence of how that lawyer will respond and how that lawyer will best help the client move forward. And so a course like one that emphasizes IP transactions gives both a perspective on how to work with IP to build things or improve things from whatever the starting point is, as well as in connection with our jointly authored casebook, a taste of some of the commercial law areas that may aid or impede the use of IP in various businesses. And it turns out that intellectual property rules and intellectual property usage interacts with a broad set of other commercial law areas, from bankruptcy to antitrust to securities law. You can keep going very far with that list. And so having some insights into as many of those generally important business law topics is another way to enhance your background. Take as many of the significant business law courses as one can, and also look for a course like the one you're already in, which is IP transactions oriented.
Yeah, no, we do. This is the follow-on course that people take after this is a 2-semester, either take it after or concurrently is a 2-semester advising the startup class, which goes more deeply into the transactional aspects of IP and builds on some of the things that they do in the overview of trade secrets, copyrights, trademarks, and patents that we're about to enter into. So I'm not gonna fight with that advice. I think that's very helpful. And for those, I want to emphasize, those who are interested in more of the policy aspects of intellectual property, that's something you will get a taste of not only in just the overview class, but also in a course like Advising the Startup, because it's heavily policy in a broad sense.
Well, and there are so many policy issues that are still in development or will be in development tomorrow. The very nature of creative effort and creative construction of business formats and processes mean that the ways that the activities of these commercializing parties, the ways that they will impact society are also changing. And that ensures that there's a new round of policy issues just around the corner.
Well, thank you very much, Professor Gruner. I think this was very helpful, and hopefully maybe we can have you as a guest speaker as well for the synchronous portions of this class where we meet face-to-face, so, or at least face-to-face via Zoom. So, but thank you again. I think this was very helpful. Thank you for taking the time.
It's been my pleasure. As with our development of our joint casebook, this is an area that I have strong and very positive feelings about. So I'm happy to give some thoughts to your students, and I hope they have a good semester ahead.
Yeah, thank you again.